One thing that you guys can really expand to help your credibility is you talk about you obtained 2 samples. You know, why do you obtain 2 samples? Well, we take 2 samples, you know, to make sure that the defendant has the benefit of the doubt. We get 2, we take their breath twice, and we use the lowest result of those 2. You know, it's just to make double sure that we're correct, you know, just kind of expand into that. And then you said it's 0.19, a significant number. Ask what the legal limit is. Get it out there so that we know. Is it 08 in Midlands?
Well, there's that one document that's 0.085. I think that's a typo.
Yeah. So just get him to say that. Artem, in objections, no more I believes.
Okay.
All right. State facts. Both of you, there were a couple of times that I was going to rule in your favor and I was going to rule in your favor after the other one got done. But before I even ruled, y'all started talking again. So be careful because you might make me change my mind. So just kind of look to the judge. You know, be willing to, have your answer ready, but kind of wait for the judge for your cue.
How do you know when the judge wants you to respond or not?
Either they'll look at you or they'll flat out ask. And sometimes, you know, the judge needs to think about the issues presented. And so sometimes they'll want to pause for a second just so they can contemplate what was said. Coach Mason?
Okay, direct examination. I'd just say speak up, and you're shifting your chair a little bit. Remember what we said in the last witness, you know, when you're facing the jury or the judge, and if they're asking you a question, you kind of lean over your shoulder to address the opposing counsel on cross-examination. On direct, though, you should be facing both the judge and your counsel. Are these indicative of a person under influence? Again, that's kind of too complicated. Just ask, what, if anything, did this behavior tell you? And, of course, throw in that foundation as well. I would love some kind of demonstrative with this witness. I think if we had a demonstration from the officer, and if we had a demonstrative with this witness, it would, and then on the first witness is going to be Taylor Hobson, which is the emotional witness. So we've got kind of something interesting happening in each of those 3 witnesses, and I think that would be.
We sent you one, but we want to change it, and you were probably really busy.
Oh yes, you did send me one.
But we want to change it, but
Okay.
And we figured you were probably really busy this week. So
Okay.
Just kind of.
Smith Cross, like I said, look over opposing counsel, but face the jury. I don't think when you get an objection overruled, make sure that I didn't hear the answer to the question after it was overruled. So make sure whenever you get an objection, it's overruled. Make sure the witness is permitted to answer that question, and so the jury can hear it. Don't argue with the witness. I think you just bring out the fact. Here's probably how I would have asked it, though these questions are kind of long. I think it kind of drops home the point. Dr. Smith, you said the reason you didn't observe Officer Foster for the whole 15 minutes was because, the defendant for the whole 15 minutes was because Officer Foster did, true? And Dr. Smith, you're aware that Officer Foster drove the defendant into the station where you were at, true? And you're aware that while Officer Foster was supposed to be observing the defendant that time period, he was driving, true? And you're aware that while Officer Foster was supposed to be observing the defendant, he was driving in the rain. And you're aware that while Officer Foster was supposed to be observing the defendant, he was driving under the darkness of night. Okay, so you kind of get the point, but you're not asking the witness for an opinion or what he would do or how he would do it or anything like that. You're just asking the fact, but the jury gets the point that while he's supposed to be observing this defendant, he's watching.
Another one to throw in is, and there's a shield, a plastic or metal shield between the officer and Danny, as you would say.
And the other thing is, I think all this stuff needs to be brought out under Officer Foster first, or brought out later if Officer Foster is called later, so that this doesn't become all. It's still technically hearsay because it's stuff the officer told him, but he's relying on it and coming to his conclusion. And it also goes to his credibility as a witness, if he knew all this stuff. That's really all I had that hasn't already been covered.
And maybe you guys want to get out some of this testimony out of this document. You admitted it, but I mean, some of the interview stuff, and now you had an opportunity to talk with the defendant. And the defendant told you that she had been drinking mixed drinks and that she started drinking at 2 p.m. that day. And you did this test at, whatever time. And the defendant said her last drink was only an hour or so ago. That all can come in too. All right, any other witnesses for the state?
At this time, Your Honor, there are no other witnesses.
All right.
I move for dismissal, Your Honor. There.
How about instead?
Do you feel
There's been no
That was
identification of the defendant, there's been no jurisdiction
Yeah, we
established, so I move for dismissal.
All right. Prosecution, in a real DUI case, the first thing the officer gets asked is, basically my testimony is, yeah, I'm a police officer. How long have you been a police officer? I've been a police officer for X years.